Good morning. I'm Joe McMahon. For more than a decade, I was the elected state's attorney in Kane County. I and my office also served as special prosecutors throughout northern Illinois, here in Cook County, but also in DuPage, Winnebago, Kendall, and McHenry counties. And I've been an attorney in Illinois for more than 30 years, both private and public sector. I and all of us are here today because the future of good government, reforms like independent maps or fair maps, and public safety, bipartisanship, in the state of Illinois are on the ballot in this election in the Illinois Supreme Court in the 2nd and 3rd districts. The independence of all three co-equal branches of government is critical to restoring Illinois as a leader in job creation, public safety, where people want to work and live. These issues are of critical importance to the people of Illinois. It's far more likely to be in front of the Illinois Supreme Court, but unlike hot-button issue of abortion, have received very little attention in the public debate concerning the Illinois Supreme Court races. There have been millions of dollars spent in this race on both sides, more money than most Illinoisans earn in a lifetime. And in particular, there has been a huge infusion of cash from the three leaders of the Springfield, Chicago Democrats. Governor Pritzker, House Speaker Welch, and Senate President Harmon all have an interest in legislative redistricting, maintaining their veto-proof supermajority in the Illinois General Assembly, and the future of the so-called Safety Act. Each of them, through their political spending, are pumping big money into the Supreme Court races at unprecedented levels for a governor and legislative leaders. Governor Pritzker, Speaker Welch, Senate President Harmon already control the General Assembly and are now trying to control who we elect to the Illinois Supreme Court in the 2nd and 3rd districts. Combined, both directly and indirectly, they have contributed more than $3.5 million into the Supreme Court race. An independent and impartial judiciary is critical to good government and is the only remaining check on the absolute political power of the Democratic Party in Cook County. Public confidence in judicial independence and impartiality is eroded when leaders of the other two branches of government try to control and dictate the outcome of judicial elections. Our three branches of government are designed to serve as checks and balances on each other. Unfortunately, the multi-million-dollar bankroll from the governor and leaders of the General Assembly serve to skew that balance and are a disservice to the people of Illinois in the 2nd and 3rd districts especially. The only recent time this level of involvement from state lawmakers in a Supreme Court race was present is when former Speaker Michael Madigan funded a Supreme Court retention race. Illinois voters who live and reside in DuPage and Kane, Lake, McHenry, and Will counties, and others in the 2nd and 3rd districts, like Winnebago, DeKalb, Kendall, Kankakee, LaSalle, Grundy, and Iroquois counties, and others. When you go to the voting booth on election day, know that your vote for the Illinois Supreme Court is one of the most important votes you can make. Know that your vote may affect the future of legislative redistricting and your own representation in the state of Illinois and in the General Assembly. Know that your vote may affect the future of the so-called Safety Act, which will have negative consequences for public safety in the state of Illinois when it goes into effect. Voters should understand that the political bosses in Springfield and here in Chicago are trying to dictate to you who you elect to the Illinois Supreme Court. And I hope that you will stand up to that power. Thank you. I'll turn it over to retired Judge Bob Spence.
Good morning. My name's Bob Spence. I'm a retired appellate court judge. I was an assistant state's attorney in both Kane and DuPage counties. And actually that's where I met Mike Burke, who is now the Supreme Court Justice in the 2nd District. We were trial partners. We worked together for 7 years. We tried serious cases. And he was an exceptional trial attorney who always gave it 100%. He became a judge in DuPage County at age 34, and he served in every area of the judicial system. And then in 2008, he became an appellate court judge. And during that entire time, he was never involved in politics. Never. This was solely based on merit. His dad was a Chicago cop. He came from a working class family, and this was all merit. This was not connections on the slightest. I became a judge in Kane County in 2001. I eventually became chief judge. I eventually was assigned to the Illinois Appellate Court, and there I worked with Mike Burke for another 7 years. And we sat on many panels together. We decided many cases together until I retired in 2019. And Justice Burke wrote thousands of opinions in cases. And some, I know, he didn't personally like the outcome, but he felt that he had to follow the rule of law, and that outcome was the inevitable result of following the rule of law. He was committed to the rule of law. And that's what's on the ballot in a week from today, is the rule of law. Is the Supreme Court going to be one that follows the rule of law, or one that is influenced by the governor and the leaders of the General Assembly? That's the question. That's the thing that voters need to consider. The Democrat Party already controls the General Assembly, the governor's office, and actually has controlled the Illinois Supreme Court for the last 58 years. 58 years. All you have to do, and this has already been touched on, I'm not going to dwell on it, just go back to your 8th grade civics class. Each branch of government is supposed to be a check on the other. The Supreme Court is supposed to be a check on the General Assembly and on the governor. We learned that in 8th grade. It's not difficult. But the other thing that's on the ballot this year, I'm just going to call it good government. And it's all about gerrymandering and fair maps. Gerrymandering, you've heard about it all over the country. Well, it is really live and doing well in Illinois. The legislative districts are drawn for one reason, and that's to keep people in power. That's the only reason. Those maps are drawn at their choosing. And the people of Illinois have been begging for redistricting, fair maps for decades. In 2016, this sounds like history, but in 2016, over 500,000 Illinois voters signed petitions to have a referendum on the ballot for fair maps. So, and actually 25 organizations joined in that effort. Very diverse organizations, the League of Women Voters, the Farm Bureau, the Union League Club and the NAACP, the Better Government Association, and the Hispanic Chamber of Commerce. And the reason for that support is because everybody recognizes this system is skewed, it's broken, it's not fair. And guess what happened to that effort? A guy by the name of John Hooker came along, and he filed a lawsuit seeking to have that referendum thrown out. And if that name sounds familiar, John Hooker, it's because it is. Because he was a friend of Mike Madigan's, and he's the Commonwealth Edison lobbyist who was indicted with Mike Madigan on federal corruption charges. That's John Hooker. So the case goes to hearing right here in this courthouse. And it goes before a judge who strikes it down. And then it gets appealed to the Illinois Supreme Court. And one of the lawyers on that appeal, just a simple point of trivia, was Lori Lightfoot when she was in private practice before she was mayor of Chicago. So it goes before the Illinois Supreme Court. The Supreme Court rules 4-3, 4 Democrats against 3 Republicans, strikes it down. So the result of that is no referendum, no change in gerrymandering, safe districts for every Democrat in the state of Illinois. Safe districts. And that's not just history, folks. It's important because people want reform. People want reform in this state. Now, whoever is elected to the Supreme Court in this election has the opportunity to rule on probably that very issue, because 6 of the 7 justices who ruled on that issue in 2016 are gone as of this December. And so we may get another chance to have fair legislative maps drawn. And just a side note, we all know that Justice Mary Kay O'Brien was formerly a member of the General Assembly, and when she was a state representative, she actually voted in favor of Mike Madigan's gerrymandered legislative maps. That was her vote. And of course she did it because it created a favorable district for her. And if you go back to 2001, the Bloomington Daily Pantograph wrote an article about this new map of Mary Kay O'Brien's and how just a little sliver of Livingston County moved into her district. It had previously been in another district, and it's where her sister lived. Now, you know, the attention to detail that these people place on those maps is just so remarkable. The detail is just so remarkable. And then after that vote on the gerrymandered maps, there's a vacancy on the 3rd District Appellate Court. And guess who gets appointed to that vacancy? Mary Kay O'Brien. Thank you, Mike Madigan. Thank you, Mike Madigan. I'm sure that's what she said. So when the legislative map question comes up again before this next Illinois Supreme Court, who do you want to rule on it? Do you want Mike Burke to rule on it, who is committed to the rule of law, who owes nobody nothing? He's not beholden to anybody? Or do you want Mary Kay O'Brien, whose career she really owes to Mike Madigan, who has benefited from this unprecedented campaign spending by Governor Pritzker and the Speaker of the House and the Senate President? In the 2nd District, do you want Mark Curran, a veteran law enforcement officer, a veteran prosecutor who calls him as he sees him? Or do you want Elizabeth Rochford, who has made campaign contributions? Now just get this. Campaign contributions to Alderman Ed Burke, not only before he was indicted, but even after he's indicted. She makes campaign contributions to Ed Burke after he's indicted for federal corruption. That is remarkable loyalty. Folks, make no mistake about it. The rule of law is on the ballot this year. Good government is on the ballot this year. And every voter needs to keep that in mind, because this election will determine whether Illinois continues down this road to economic ruin, to ever-increasing crime, or whether we have a chance for a new beginning. And I'll turn it over now to Senator John Curran.
Thank you, Judge. Good morning. My name is John Curran. I am the state senator for the 41st District. Prior to that, I was an assistant state's attorney here in Cook County for 19 years. I'm currently the minority spokesperson on the Senate Ethics Committee. And probably most importantly, I opposed the Safety Act when it was passed in January of 2021. The future of the so-called Safety Act is likely to be decided in these Illinois Supreme Court races. As the public undoubtedly knows by now, the Safety Act passed in the early morning hours of January 13, 2021, after that 800-page bill was filed and we were given 1 hour to read it. While that bill has already had disastrous effects for law enforcement, the worst components of the Safety Act are yet to go into effect. That starts January 1st of 2023. And on this date, the state of Illinois is going to get a new bail system throughout the entire state. And this bail system will eliminate any use of cash bail. But more importantly, and disastrously, it's going to tie the hands of judges. It's going to prevent judges from making assessments on a charged defendant's risk to the public. This law, hamstringing prosecutors, judges, and law enforcement, will lead to violent felons being released. Violent offenders will slip through the cracks and will be back out amongst the public. Further, this law raises the standard on willful flight. And now a prosecutor, to show flight, must show that someone is planning to conceal oneself to evade prosecution. A very heightened standard, unlikely to be met. Failure to show up in court for any reason, it no longer will be evidence of avoiding prosecution or flight. Another component of the Safety Act that's already gone into effect is this 48-hour rule being gone from electronic home monitoring. As Cook County here uses electronic home monitoring to greater and greater effect in releasing charged individuals, they now get to skip out on electronic home monitoring for 48 hours before they can be charged with escape. Cutting one's bracelet off is not evidence of evading home monitoring. You have to be gone 48 hours. This has and continues to be a risk to public safety. All told, the Safety Act is going to lead to greater rates of recidivism and more crime throughout this state. Take a look at New York, and that's what you're going to see here throughout Illinois. Luckily, there are people fighting the Safety Act and its implementation. Sheriffs and state's attorneys, Democrats and Republicans in law enforcement have banded together and have filed multiple suits against the Safety Act, against Governor Pritzker and the Attorney General. Those lawsuits are now consolidated in Kane County under the case of Roe versus Raoul. We're very confident that if that lawsuit, if that litigation actually gets an independent hearing from the Illinois Supreme Court, their challenge will be granted, that the Safety Act will be struck down, and that issue will be returned to the legislature to ensure that we proceed going forward with the public's safety as a major component of any future change. However, the proponents of the Safety Act, Governor Pritzker and the leaders in the Democratic majorities in the House and the Senate, have been significant campaign contributors to both Justice O'Brien and Judge Rochford. It is certainly reasonable to ask the voters of the 2nd and 3rd districts of the Illinois Supreme Court, based upon the large, substantial financial backing Justice O'Brien and Judge Rochford have seen from the champions of the Safety Act, will their concerns for their own public safety be given fair consideration by the judge and justice in litigation like the challenge in Roe, as this is going to be decided ultimately by who we elect in the Illinois Supreme Court races. With that, I want to thank you for your time, and we're going to open it up to questions.
Mr. McMahon, go back to the...
So before we open it up to questions, I'd like to add just one more thing. Just yesterday, the public learned for the first time that Governor Pritzker has contributed another $500,000 directly to the opponents of Justice Burke and Mark Curran. This brings the governor's latest campaign personal contributions to the campaign to over $2 million. This latest campaign contribution came from one of his many financial trusts, not his own campaign fund like past contributions came from. This is nothing more than an attempt